Professor H.K. Nagarajan. I am Professor in National Law School of India University. Today, I will be speaking about human rights international parameters. The objective of the study is to provide an organized study to enable a reader to comprehend the international development and the contemporary state of international human rights parameters. As an introduction, I can say human rights, being the basic rights of all people all over the world, are entitled to it. Therefore, there cannot be any discrimination in the enjoyment of human rights. Norms of human rights are universal on the ground that the selected parameters are fundamental and therefore they should trump over all other preferences, though there is an advocacy that the values vary with the culture and therefore dependent upon space and time. Human rights should be a means to overcome human suffering and to secure the conditions for leading a minimally good life. It is necessary that the states or other entities holding certain mandate and their constitution should translate the right into action. Coming to development of international human rights law before the Second World War, the scenario. Development earlier to the Second World War, as we can see, is the 1815 Vienna Declaration of the abolition of a slave trade, and also 1885 General Act of Berlin on abolition of slave trade, and finally 1890 General Act of Brussels on slave trade. Coming to the mandate of the League of Nations, Article 22, Class 5 of the League of Nations Covenant provided for freedom of conscience and religion and the prohibition of abuses such as the slave trade, the arms traffic, and the liquor traffic, and Article 23, Class A provided for endeavoring to secure and maintain fair and humane conditions of labor for men, women, and children. The most remarkable development, however, was in respect of international protection of minorities by concluding agreements. The establishment of the International Labour Organization in the year 1919 and conclusion of a number of conventions for the improvement of the conditions of the working class may be considered as the other development. Now, coming to the post-United Nations Charter development. Charter of the United Nations itself accorded formal and authoritative expression to the human dignity by providing for human rights in various provisions such as Article 1, Clause 3, Article 13, Clause 2, Paragraph B, Article 55, 56, Article 62, Clause 2, and also Article 68. Next, the Universal Declaration of Human Rights, adopted by the General Assembly of the United Nations in the year 1948, giving a decisive direction, has demonstrated that it is capable of serving as guide to all states in providing the clear content of human rights. A decisive step was taken in the year 1966 by adding two covenants at the universal level when the General Assembly adopted the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. There have been an increasing number of conventions, declarations, recommendations and resolutions demonstrating the continuous activity of international organs in pursuit of development of human rights. Now, going to the development of human rights under the United Nations system, that is under the charter-based system. The charter-based system has been developed under the United Nations Economic and Social Council, which set up the Commission on Human Rights in the year 1946 as mandated by Article 68 of the United Nations Charter. Two mechanisms emerge. First, the resolution number 1235 and second, resolution number 1533, adopted in the year 1959 and 1970 respectively, and also a number of special procedures were established by the Commission. In the face of severe criticisms against the Commission on Human Rights owing to the bad record of the human rights, several member states of the Commission in 2006, the General Assembly decided to follow the Secretary General's recommendation creating the Human Rights Council as a replacement to the Commission on Human Rights. The Human Rights Council has retained most of the special procedures and also introduced the Universal Peer Review, that is UPRWAT as it is called. Starting in April 2008, Human Rights Advisory Council is established as a think tank for the Council and work at its direction. The Commission on the Status of Women is also established as a functional commission of the United Nations Economic and Social Council. It is the principal global policy-making body dedicated exclusively to gender equality and advancement of women. Now, going into the details of the human rights under the Charter-based protection, the powers of the General Assembly under Article 10 is confined to discuss any questions or matters related to human rights subject to limitation imposed by Article 2, Paragraph 7, not to intervene in matters which are essentially within the domestic jurisdiction of states. General Assembly also could initiate studies for the purpose of assisting in the realization of human rights and fundamental freedoms without distinction as to race, sex, language, or religion, that is under Article 13, Clause B of the Charter, to draft international conventions relating to human rights under Article 62, Paragraph 3 of the Charter, and to establish subsidiary organs when it deems necessary for the performance of its actions under Article 22 of the Charter. In the process, the task of the General Assembly was to choose between a restrictive interpretation and a liberal one to the concept of domestic jurisdiction of the Charter. The former would have expanded the scope of human rights in the Charter scheme of protection, but the latter would have allowed a wider scope for the domestic jurisdiction and constricted the powers of the General Assembly in its endeavors in protecting human rights. The approach of the Assembly was to hold the human rights as the sine qua non in the cause of maintaining international peace. The Assembly approached the case of violation of human rights as amounting to impair the friendly relations among states. In the 2 decades from 1950 onwards, the approach of the states facing violations of human rights underwent a sea change. The General Assembly could freely assert jurisdiction in cases of large scale or massive violations of human rights, and the only reason on which targeted states could have defended was by pleading that the alleged violations had not taken place. There were also positive gains to the General Assembly in its fact-finding role. The action of the General Assembly in establishing a special committee on apartheid in 1962 to look into apartheid policies of South Africa and to give report, sending its mission to South Vietnam in 1963 to inquire into the prosecution of Buddhists by the government, constituting a special committee in 1968 to look into Israeli practices on the territories occupied in 1967, show the way in which it proceeded, notwithstanding lack of cooperation of those states with it. The period from the 90s calls for attention owing to far-reaching changes in the world. The numerical advantage of the third world states brought about perceptible change in the stature in the General Assembly. The sharp division between the developed and the developing states on the subject of human rights was the fallout of this development. The violation of human rights was sought to be explained away with the justification by the developing states that the fundamental causes for violation of human rights was structural violence. The General Assembly, therefore, notwithstanding the plea of structural violence by the developing states, was able to demonstrate that in the event of grave, repeated and large-scale violations, it could intervene, and the justification of domestic jurisdiction or state sovereignty under Article 2, Paragraph 7 would no more prevail. From the last phase of the 20th century, the relevance of the role of the Assembly in matters of protection and promotion of human rights has been disputed, that with the establishment of the Commission on Human Rights and the subsidiary bodies for the protection and promotion of human rights, whether there is any space left for the General Assembly to make any distinct contribution in the field of human rights. In the establishment of the Economic and Social Council as one of the primary organs of the United Nations, the Charter of the United Nations envisages Economic and Social Council to make or initiate studies and reports with respect to international economic, social, cultural, educational, health and related matters, and can make recommendations on such matters to the General Assembly and also to relevant specialized agencies. Though initially the Economic and Social Council played considerably active role on the issues of human rights, from the second half of the 1950s, its role began to fade. The Economic and Social Council took active part in the drafting of the 1948 Genocide Convention. However, by 1950, when the Commission on Human Rights was totally involved in the drafting of the two human rights covenants, it was the Economic and Social Council that is engaging in the issues arising out of human rights problems. Thus, during this period, the Economic and Social Council was itself dealing with several problems of human rights of general nature, leaving specific issues to be dealt with by the General Assembly, be it the plight of prisoners in Spain, or the problems of foreign wives of Russians, or the treatment of Indians in South Africa. In the year 1967, on the basis of the recommendations from the Commission on Human Rights, its resolution number 1235 facilitated the Commission to study the situations revealing consistent pattern of violations of human rights. In the very same year, under 1235 procedure, an ad hoc working group of the Commission on Human Rights was established to look into the violations of human rights in South Africa. At the beginning of 1970, a number of United Nations organs were able to exercise control over developing countries in matters of human rights, which could not have been conceived as possible in the past 2 decades. Thus, domestic jurisdiction was no more a hurdle for the Economic and Social Council to intervene in matters of human rights. Since 1990s, efforts were made to make the Economic and Social Council a more relevant body for the purposes of understanding the task of protection and promotion of human rights. In the year 2006, with the replacement of the Commission on Human Rights by the Human Rights Council, the role of the Economic and Social Council has been further reduced. In the year 1946, the Economic and Social Council establishes the Commission on Human Rights. For a period of 60 years till 2006, the Commission on Human Rights, with its 53 members, was able to engage in a number of activities for the cause of human rights. The Commission made a substantial contribution not only in setting standards of human rights by involving itself in the drafting of the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, and others, but dedicated itself in developing the institutional capacity of the United Nations to promote and protect human rights. In the first 2 decades, though the petitions to the United Nations were pouring into, the Commission on Human Rights had no power to take any action in regard to any complaints alleging violations of human rights through those petitions. While these communications were received by the Commission on a confidential basis, without disclosing identity of the authors, it was only, however, from 1959 when the Economic and Social Council adopted its resolution 728 of 1959, the Secretary General was required to send the non-confidential list of all communications to all the members of the Commission. Any communication referred to a state was sent to the concerned government, whose response to it was optional. This entire procedure, but for the educative effect, remained to be unproductive. In the mid-60s, the third world countries supported a non-treaty based communication system on the lines of a communication system in respect of Convention on the Elimination of all forms of racial discrimination. This culminated in the adoption of 2 separate procedures by the Economic and Social Council. First was the resolution number 1235 1967, establishing the principle that the Commission could examine and respond to allegations of violations of human rights and also providing for the required authorization to engage in public debate. The second was the resolution number 1503, which came into effect in 1972, that provided a procedure to meet situations revealing a consistent pattern of gross and reliably attested violations of human rights. The 1503 procedure is not intended to give redressal for violations of human rights. The 1503 procedure, unlike that of 1235, is entirely confidential. It is difficult to assess the efficacy of a 1503 procedure. In the very beginning, the procedure was almost cold-shouldered by Greece, Iran, and Portugal. Yet the 1503 procedure was used as a tool in the struggle against racism and colonialism. On the other hand, the 1235 procedure initially got off with a stormy session as in Haiti and Greece. But by the beginning of the 80s, the situation got changed. Non-governmental organizations were able to create a more informed public opinion, and owing to the domestic pressure, the governments were compelled to consider in terms of protection of human rights. Along with 1503 and 1235 procedures, one has to consider the evolution of thematic procedures also. The origin of this lies in the establishment of a working group on enforced involuntary disappearances in the year 1980 to respond to situations arising in Argentina and Chile. In the case of Chile, the rapporteur of the Commission on Human Rights had to engage for considerable time both into the phenomenon of disappearance and also for establishing the responsibility of the government. The disappearance group paved the way for other thematic procedures such as special procedure on summary or arbitrary executions in 1982, special rapporteur on torture in 1986, special rapporteur on religious intolerance in 1987, special rapporteur on mercenaries in 1988, and working group on arbitrary detention in 1991. In the face of severe criticism against the Commission on Human Rights, owing to the bad record of human rights of several member states of the Commission, in the year 2005, the former United Nations Secretary General Kofi Annan called for the replacement of the Commission by a smaller, permanent, and human rights compliant council. The major reason for replacing the Commission was the very selective way in which it exercised its country-specific mandate, due mainly to the political bias of representatives and the ability of more powerful countries to deflect the attention away from themselves and those enjoying their support. In the year 2006, the General Assembly Resolution 60/251 set out the broad structure of the future system and handed over the responsibility for working out the detail to the new Human Rights Council, which replaced the Commission. The resolution established that the Council was to be composed of 47 members who cannot serve for more than 2 consecutive terms. The benchmark was that nothing should be done to harm the existing protection of human rights, and if possible, any proposals for reform should represent progress. The members of the Council are elected by a simple majority vote by the General Assembly. The composition of the Council membership is based on regional basis. The Council is required to promote human rights education and learning, to serve as a forum for dialogue on thematic issues, to make recommendations to the General Assembly on developing new human rights standards, to provide assistance in preventing human rights violations through dialogue and cooperation, and to respond to human rights emergencies. The resolution also requires the Council to undertake Universal Periodic Review called UPR based on objective and reliable information of the fulfillment of each state of its human rights obligations and commitments, ensuring universality of coverage and equal treatment. Universal Periodic Review is a unique process involving a periodic review of human rights records of all the members of the United Nations. Under the UPR mechanism, each member of the United Nations is reviewed once in 4 years. Accordingly, 48 states should be reviewed every year during the 3 two-week sessions. The review is conducted by the UPR working group consisting of the 47 members of the Council. Each state review is assisted by 3 states working as rapporteurs who are called as TRIOCA. Reviews conducted under UPR are based on 3 reports: the national report, compilation of the United Nations information, and information from other stakeholders. The UPR makes an assessment of human rights compliance in respect of the state and a review in the light of obligations set out in the United Nations Charter, the Universal Declaration of Human Rights Conventions to which the concerned state is a party, voluntary pledges and commitments made by the state, and applicable international humanitarian law. On the basis of the review, the outcome report is prepared. The outcome report provides a summary of the actual discussion consisting of questions, comments, and recommendations made to the state and a review, and also the responses to them made by the reviewed state. The report has to be adopted by the plenary session of the Human Rights Council. The state has the primary responsibility to implement the recommendations of the final outcome report. The UPR ensures that all countries are accountable for progress or failure in implementing the recommendations. The Human Rights Council's review of the first cycle of 4 years between 2008 and 2011 and the second cycle between 2012 and 2016 have been completed, and the third cycle between 2017 and 2021 is in progress. Other functions of the Human Rights Council are Human Rights Council's response to country situations when it holds special session. Special procedure assumed by the Human Rights Council is the general name given to the mechanisms established by the Commission on Human Rights to address either specific country situations or thematic issues in all parts of the world. Complaint procedure of the Human Rights Council also could be included. Pursuant to Human Rights Council Resolution 5/1, the Human Rights Advisory Council is established as a think tank of the Council and work at its direction. The Advisory Committee is composed of 18 independent experts from different professional backgrounds, representing different regions of the world. The Advisory Committee provides expertise to the Council in the manner and form requested by it. Now we come to development of human rights under the United Nations system, that is treaty-based system. The treaty bodies constitute the fundamental pillar of the international human rights protection system. The treaty body system has grown exponentially since the establishment of the first treaty body in 1969, a growth which has greatly enhanced human rights protection. There are 10 core international human rights treaties. Each of the existing core human rights treaties has an expert body called the committee to monitor and implement treaty guarantees by states parties created in accordance with the provisions of the respective treaties. Each treaty body has developed its own tools for monitoring and evaluating the human rights standards in compliance with the respective treaties, including state reporting, general comments, inquiries, interstate complaint procedure, and individual communication procedure. In the case of state reporting, state parties to the core human rights treaties have an obligation to furnish regular reports called periodic reports, giving particulars on implementation of treaty protection at the national level. In the very beginning, the state party has to provide an initial report on the particulars about the constitutional, legislative, administrative, and judicial system and their work. In addition to this, state party also should submit a common core document used by all treaty bodies, providing in general domestic, legal, and constitutional framework for the purpose of protecting human rights within the territory of that state. Both the common core document and the treaty-specific document form an integral part of each state's report. The exercise involved in the preparation of the state reports will provide an opportunity for the state party to make a comprehensive review of the steps that it has taken to comply with the standards prescribed in the relevant international human rights treaties. It would also enable the committee to monitor the progress made by the state party in facilitating the enjoyment of human rights prescribed in the treaties. It would further assist both the state party and also the committee in searching and identifying the shortcomings of the domestic implementation of the treaty rights and the problems encountered in their implementation. The examination of the state report is held in public sessions in the presence of a representative of the state party concerned. This entire procedure is called as constructive dialogue. A successful examination of the state party's report by the treaty body requires positive cooperation with the farmer. The committee encourages the use of the list of issues to better prepare for a constructive discussion. After this, the members of the committee may provide comments or even put questions in relation to the replies given. After the examination of the periodic reports in the public session, each treaty body adopts its concluding observations or concluding comments. The country's special rapporteur, on the basis of the constructive dialogue held during the plenary session, drafts the concluding observations for the consideration of the committee. Ordinarily, the concluding observation or comment comprises of an introduction, positive aspects of the situation of human rights, factors and difficulties impeding the implementation of human rights treaty, principal subjects of concern and suggestions and recommendations. Finally, concluding observations are sent to the concerned state and also they are concluded in the annual report of the committee. Generally, states are invited to report back within 1 year on what follow-up action can be taken. Most of the treaty bodies have also appointed a special rapporteur for follow-up to concluding observations. The human rights treaty bodies have also developed various strategies to meet the problem of failure of the states to fulfill the reporting obligation. Generally, the committees try to persuade states to promptly submit their periodic reports to enable the committees to examine the human rights situations in the territories of those states. General comment or general recommendation is another important function of the committee used to interpret the provisions of the conventions on respective human rights treaties in order to eliminate doubts about the scope and meaning of the articles. Though general comments are not legally binding, they are frequently referred to by states in the context of periodic reports and complaints procedure and sometimes even by national courts. There are three main procedures for bringing complaints of violations of the provisions of the human rights treaties before the human rights treaty bodies. First, inquiries. Second, interstate complaints. And third, individual communications. When reliable information is received on serious, grave or systematic violations by a state party of the convention, the committees may on their own initiative start inquiries. However, such inquiries can be undertaken with respect to those states parties who have recognized the competence of the relevant committee to conduct the inquiries. The committee, on the basis of the observations received from the state party and other relevant information available to it, may decide to designate one or more of its members to conduct an inquiry and report immediately to the committee. The findings of the members of the inquiry committee are examined by the committee and then transmitted to the concerned state party along with the committee's observations and recommendations. Under interstate complaint mechanism, almost all the human rights treaties have provisions permitting state parties to complain to the relevant treaty bodies about the alleged violations of the treaty by another state party. Interstate procedures so far have not been used by the states parties. Finally, under individual complaint mechanism, a complaint under one of the core treaties can be brought only against a state that satisfies two conditions. First, it must be a party through ratification or accession to the treaty in question, providing for the rights which have allegedly been violated. Second, the state party must have recognized the competence of the committee monitoring the relevant treaty to receive and consider complaints from individuals. Anyone can lodge a complaint with a committee against a state that satisfies these two conditions, claiming that his or her rights under the relevant treaty have been violated. It is not necessary to have a lawyer prepare the complaint, though legal advice may improve the quality of the submission. One may also bring a claim on behalf of another person on condition that his or her written consent is obtained. In certain cases, one may bring a case without such consent, for example, where a person is in prison without access to the outside world or is a victim of an enforced disappearance. In those cases, the author of the complaint should state clearly why such consent cannot be provided. A complaint to a committee, also called a communication or a petition, need not be presented in a particular form. The complaint should provide basic personal information, alleged victim's name, nationality, date of birth, and specify the state party against which the complaint is directed. If the complaint is brought on behalf of another person, proof of his or her consent should be provided. The complaint should also furnish in detail the steps taken to exhaust the remedies available in the state party against which the complaint is directed. That is, steps taken before the state parties, local courts and authorities. The requirement to exhaust domestic remedies means that the claims must have been brought to the attention of the relevant national authorities up to the highest available instance in the state concerned. Based on the above mentioned requirements, the committee will decide whether the case should be registered, that is to say, formally listed as a case for consideration by the relevant committee. At that point, the case is normally transmitted to the state party concerned to give it an opportunity to comment. The state is requested to submit its observations within a set time frame. The two major stages in any case are known as admissibility stage and the merit stage. The admissibility of a case refers to the formal requirement that a complaint must satisfy before the relevant committee considers its substance. The merits of the case are the substance on the basis of which the committee decides whether or not the alleged victims' rights under the treaty have been violated. As a general rule, the committee considers the admissibility jointly with the merits. If the state party challenges the admissibility of the complaint, it can do so by providing arguments within the first 2 months of that period. The complainant is always given the opportunity of commenting on the state party's observations within a set time frame. When comments are received from both parties, the case is ready for a decision by the relevant committee. If the state party fails to respond to the complaint, even after receiving several reminders from the Secretariat, the committee will take a decision on the case based on the information submitted by the complainant. Some committees may, at any stage before the case is considered, issue a request to the state party for interim measures in order to prevent any irreparable harm to the complainant or alleged victim in the particular case. A decision to issue a request for interim measures does not imply a determination on the admissibility or the merits of the communication. When examining admissibility, the committee may consider the following factors. The alleged violations must relate to a right actually protected by the treaty. If the relevant committee considers, in the light of the information before it, that the complainant has not sufficiently described by the facts and arguments for a violation of the covenant, it may reject the case. If the complaint has been submitted to another treaty body or to a regional mechanism, the committee cannot examine the complaint. In some cases, the committee may consider the claims to be frivolous, vexatious, or otherwise inappropriate use of the complaint procedure and reject. Once a committee considers a complaint admissible, it proceeds to consider it on its merits, stating its reasons for concluding that a violation has or has not occurred under the applicable treaty provisions. The committees consider each case in closed session. Once the committee takes a decision on the case, it is transmitted to the complainant and the state parties simultaneously. One or more committee members may append a separate opinion to the decision if they come to different conclusions. When the committee decides that the facts before it disclose a violation by the state party of the complainant's rights under the treaty, it invites the state party to supply information within a set time frame on the steps it has taken to give effect to its findings and recommendations. When the committee decides that there has been no violation of the treaty or that the complaint is inadmissible, the case is closed. The committee's decisions represent an authoritative interpretation of the treaty concerned. They contain recommendations to the state party, but they are not legally binding upon the states. When the committee concludes that a violation of the covenant has taken place, the state is invited to provide information within 180 days on the steps it has taken to implement the recommendations. Information related to follow-up to the committee's views and recommendations is not confidential, and the meetings during which the information is discussed are public. Now we come to regional human rights organizations. Regional human rights systems consisting of regional instruments and mechanisms play an important role in the promotion and protection of human rights. Regional human rights instruments consisting of treaties, conventions, declarations help to localize international human rights norms reflecting the particular human rights concerns of the region. Regional human rights mechanisms consisting of commissions, special rapporteurs, courts would help to implement these instruments on the ground credible regional human rights systems have been established in Europe, America, and Africa. Further, where the state party is invited by the committee, it is required to inform the measures taken by it in response to the inquiry. The inquiry procedure is confidential. Now we come to Regional Human Rights Organization in Europe. European Convention on Human Rights was the Council of Europe's first legal treaty to protect human rights, as well as the first international human rights treaty with enforceable mechanisms. It provides for the maintenance and further realization of human rights and fundamental freedoms. The treaty deals mainly with civil and political rights. The European Social Charter, adopted in 1961, guaranteeing fundamental social and economic rights, and the European Convention for the Prevention of Torture was adopted in 1967, are other significant instruments. The European Court of Human Rights was established with the convention located in Strasbourg. It has jurisdiction over COE member states that have opted to accept the court's optional jurisdiction. Once the state has done so, all court decisions regarding it are binding. Now I'll talk about Regional Human Rights Organization in America. The American Declaration of the Rights and Duties of Man, signed in April 1948, became the first international document listing universal human rights and proclaiming the need to protect these rights, and the American Convention on Human Rights of 1969 was the second instrument, focusing mainly on civil and political rights. Some of the other human rights instruments are Inter-American Convention to Prevent and Punish Torture of 1985, Inter-American Convention on the Forced Disappearance of Persons of 1994, Inter-American Convention on Prevention, Punishment and Eradication of Violence against Women of 1994, and Inter-American Convention on the Elimination of All Forms of Discrimination against Persons with Disabilities of 1999. The Charter of the Organization of American States of 1948 includes several structures for protecting human rights. The Inter-American Commission on Human Rights oversees petitions made against a member state for violations of human rights protected under American Declaration of the Rights and Duties of Man, 1948. The Inter-American Court of Human Rights was established in the year 1978 with the entry into force of the American Convention. The court may hear the cases where it is referred to either by the Commission or the state involved in the case within 3 months of the release of the Commission's report. An individual or a petitioner may not independently bring forth a case to be considered by the court. Now we go to Regional Human Rights Organization in Africa. The African Charter on Human Rights and People Rights of 1981 contains a long list of rights covering a wide spectrum, not only of civil and political rights, but also of economic, social and cultural rights. The African Charter further created the African Commission on Human Rights, on Human and People's Rights, to promote human and people's rights and ensure their protection in Africa. The 1998 Protocol on the Statute of the African Court of Justice and Human Rights, adopted on the 1st July 2008, replaces the Protocol to the African Charter on Human and People's Rights, the establishment of the African Court on Human and People's Rights, and the Protocol of the Court of Justice of the African Union of 2003. Now we come to human rights standards application. It is indispensable to frame appropriate international standards of human rights to serve as precondition to achieve the goals designed to benefit the individual. Since the true test of human rights takes place within the framework of the states, it is necessary the standards elaborated at the international level should be carried without any material distortion to the national level. The International Covenant on Civil and Political Rights, International Covenant on Economic, Social and Cultural Rights, International Convention on the Elimination of All Forms of Racial Discrimination, and other human rights treaties, along with UN declarations and resolutions, together represent international human rights standards. Now coming to human rights standards guidelines. In the year 1986, the United Nations General Assembly, in its resolution A/RES 4120, recalling the extensive network of international standards in the field of human rights, impressed upon the states in taking into consideration the following guidelines in the in developing international instruments for this purpose. First, to be consistent with the existing body of international human rights law. Second, to be a fundamental character and derived from the inherent dignity and worth of the human person. Third, to be sufficiently precise to give rise to identifiable and practical rights and obligations. Fourth, to provide where appropriate, realistic and effective implementation machinery, including reporting systems. Fifth, to attract broad international support. At the same time, it has also been observed that standard setting within the corridors of the United Nations and in the human rights arena would have to respond to a more diverse world, thus rendering the process far more complex. It has been argued that all normative principles are based necessarily on specific cultural and philosophical assumptions. Now, if you go to measurement of human rights, it is strongly felt that in addition to evaluating the impact of legislative and executive action, there is also an immediate necessity to pursue analytically the determinants of human rights violations and their effect. This calls for specific measure to address those issues. Therefore, it is observed that measurement of human rights could be satisfactorily conducted in three-dimensional approaches. First, the scope, that is the kinds or types of harm inflicted. Second, the intensity, that is the frequency of occurrence of each of the various types of state violations during a given time period. And third, the range, that is the size of the population targeted for violation of human rights. Thus, for the purposes of measuring compliance of human rights, indicators have been used as tools. Indicators are to greater extent scientific techniques to impart concrete and practical tools for measuring compliance of human rights. The indicators are frequently being made use of at the international level, whether by the human rights treaty bodies or in the Universal Periodic Review. Further, in the General Comment number 14 of 2000, the Committee on Economic, Social and Cultural Rights drew attention to the need for a four-step procedure covering indicators, benchmarks, scoping and assessment for monitoring the implementation of our human rights standards. The human rights indicators are utilized with three objectives. First, to monitor compliance with and fulfillment of human rights commitments. Second, to measure the progress of human development in the perspective of our human rights. And third, to evaluate the effect of particular rights-based development schedule. Now, going to limitation upon human rights, restrictions on human rights. Rights and freedoms guaranteed by the International Conventions on Human Rights are not absolute. At the same time, it does not endorse imposition of undue restriction on human rights. All major international human rights instruments impose restrictions on rights for the protection of the rights of others, public order, public health, public morals, and national security for the promotion of general welfare. In Celebrity versus Uruguay, in 1981, the committee interpreted Article 5, Clause 1 to prohibit a state from perpetrating violations of the covenant on the territory of another state. In Lawless versus Canada, the committee held that statutory restrictions affecting the right to residence on a reserve of a person belonging to the minority concerned must have both a reasonable and objective justification and be consistent with other provisions of the covenant. In Petrorica versus Uruguay, it was held that the freedom of expression should only be subjected to restrictions necessary for respect of the rights or reputations of others under Article 19, Paragraph 3, Clause A, and for the protection of national security or of public order or of public health or morals under Article 19, Clause 3, Subclause B, and also held that the principle of proportionality has to be applied. In Anatoly Poplavny and Leonid Sudarenko versus Belarus of 2016 held that the freedom of opinion and freedom of expression are indispensable conditions for the full development of a person and must be applied only for those purposes for which they are prescribed and must be directly related to the specific need on which they are predicated. In Andrei Sevedov versus Kazakhstan of 2017 held that any restriction on the freedom of expression must not be overbroad in nature and it must be least intrusive. In Vizencio Scarno Spisov versus Bolivarian Republic of Venezuela of 2017, while examining the aspect of fair trial on the issues of arbitrary detention under Article 9, conditions of detention under Article 9, 10 and 14, right to due process articles under Article 9 and 14, and right to political participation under Article 25, held that arbitrariness must be interpreted broadly to include elements of inappropriateness, injustice, lack of predictability, and due process of law, as well as the elements of reasonableness, necessity, and proportionality. In Leal and Miloica, Blagovic versus Bosnia and Herzegovina, 2017 decision, examining the issues related to right to life under Article 6, cruel, inhuman, and degrading treatment or punishment under Article 7, right to privacy under Article 17, and right to family life under Article 23, paragraph 1, observed that not only the state was under an obligation to provide effective remedy, but was also under an obligation to prevent similar violations in future. In Purna Maya versus Nepal, while examining inter alia issues relating to Article 3, that is equal rights of men and women, and Article 26, non-discrimination on the basis of gender, held that burden of proof need not always rest on the petitioner alone, especially in view of the fact that the state party had better access to information than the petitioner. In Ziraboy Bove versus Tajikistan of 2017, while considering issues related to Article 6, paragraph 1, that is right to life, and Article 7, right against torture, inhuman or degrading treatment or punishment, the committee reiterated that by arresting and detaining individuals, the state took the responsibility to take care of their life, and that criminal investigation and subsequent prosecution were necessary remedies for violations of human rights such as those protected by Article 6. Now, coming to the decisions of the Committee on the Elimination of Racial Discrimination and Restrictions. In the Jewish community of Oslo versus Norway of 2005, while examining the issues of violations of Article 4 to declare as offences punishable by law, dissemination of ideas on racial superiority or hatred, incitement to racial discrimination and acts of violence, and of Article 6 to provide effective protection and remedies through competent national tribunals, held that definition of racial discrimination in Article 1 expressly extends beyond measures which are explicitly discriminatory at face value, but are discriminatory in fact also and effect. That is, if they amount to indirect discrimination, and in assessing such indirect discrimination, full account of the particular context and circumstances must be taken. In BMS versus Australia of 1999, while examining whether the quota system introduced by Australia in the year 1992 on the number of doctors trained overseas who passed the first stage of multiple choice examination to appear for the second stage, and as a result of which the petitioner, an Australian citizen of Indian origin who had graduated from India, though passed the first stage, could not participate in the second stage, had violated Article 5E1, that is right to work, to pre-choice of employment, came to the conclusion that since all overseas trained doctors were subjected to the same quota system, it was not possible to reach the conclusion that the system worked to the detriment of persons of a particular race or national origin. In DR versus Australia of 2009, while examining issues in respect of Article 5E4, Social Security, 5E5, Right to Education and Training, and 5D3, Right to Nationality, whether the restrictive definition of permanent resident under the Australian Citizenship Act unduly restricted the right to nationality under the Convention, observed that there were no obstacles imposed to acquire permanent residency in Australia or Australian citizenship, and therefore the Act in question did not make any distinctions based on national origin. Coming to the decisions of the Committee on the Elimination of Discrimination Against Women on Restriction, Anna Belasova versus Kazakhstan, decided in 2015, the committee was considering the issues under Article 2E, that is, obligations of the state party to establish legal protection of the rights of women on an equal basis with men, Article 5A, obligation to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices, Article 11, to take appropriate measures to eliminate discrimination against women in the field of employment, and Article 14, the obligation of the state parties to take into account the particular problems faced by rural women. The committee observed that the state parties, institutions and courts failed to give due consideration to the petitioner's complaint of gender-based violence, which took the form of sexual harassment in the workplace, and the pressure exerted on the author and the nature of the threat and harassment, as well as the attempts to extort money, all stemmed from her being a woman in a subordinate and powerless position and constituted a violation of the principle of equal treatment. In SVP versus Bulgaria of 2012, the committee came to the conclusion that the state party had violated Article 2A to embody the principle of equality of men and women, B, to adopt appropriate legislative and other measures prohibiting discrimination, E, to take appropriate measures to eliminate discrimination by any person, organization or enterprise, F, to take appropriate legislative and other measures to modify laws constituting discrimination, G, to repeal national penal laws constituting discrimination against women, and therefore was required to provide reparation, including appropriate monetary compensation commensurate with the gravity of the violations of the rights. In RKB versus Turkey, decided in 2012, the committee opined that the former employer's treatment of the petitioner in the context of the unlawful termination of her labor contract by violating her right to work and equal treatment constituted gender-based discrimination under Article 11, paragraph 1A and D of the Convention, and therefore the author had suffered a violation of her rights. Now, going to the Committee Against Torture on Restriction, cases decided by the committee. The Rashid Jaiden versus Tunisia, decided in 2012, the committee concluded that the petitioner's allegations must be taken fully into account, and that the abuse to which he was subjected was perpetrated by officials of the state party in an official capacity, and also that the acts in question constituted an act of torture within the meaning of Article 1 of the Convention. In Enama Asfari versus Morocco, decided in 2016, the committee reiterated its jurisprudence that any person deprived of liberty must be given access to prompt and independent legal and medical assistance, and must be able to contact his family in order to prevent a torture, and failure to conduct a thorough, prompt and impartial investigation denied the petitioner any possibility of exercising his right to redress, and also any statement obtained as a result of torture loses its probative value. In GI versus Denmark of 2017, the petitioner had entered Denmark without valid travel documents and sought asylum. The Danish Immigration Service rejected his asylum claim and refused to grant him a residence permit. The committee recalled that although it was for the petitioner to establish prima facie case to request asylum, it did not exempt the state party from making substantial efforts to determine whether there were grounds for believing that the petitioner would be in danger of being subjected to torture if returned, and concluded that the state party had failed to determine whether there were substantial grounds for believing that the petitioner would be in danger of being subjected to torture if returned. In GE versus Australia, decided in 2017, the committee adopted the state's contention that the existence of a pattern of gross, flagrant or mass violations of human rights in a country did not as such constitute sufficient reason for determining that a particular person would be in danger of being subjected to torture on return to that country, since domestic authorities found that the petitioner lacked credibility owing to inconsistencies in factual account of events. A proclamation of emergency is capable of sending the message that restrictions on human rights are necessary. It should be temporary, with the assurance that such restrictions would be withdrawn and the rights to the fullest measure in accordance with the Human Rights Convention would be made available once the crisis disappears. When a state faces a threat to its security or continued survival, the pressure to adopt emergency measures, including suspensions of civil and political liberties that the state has previously pledged to uphold, is often overwhelming. Article 4 of the International Convention on Civil and Political Rights provides an elaborate international regime of limitations, safeguards, notifications, and review procedures for the purposes of enforcing derogation and requiring for its application the existence of a public emergency threatening the life of the nation, and further making it obligatory to officially proclaim the emergency. The state's parties are permitted to derogate from only a certain civil and political rights strictly required by exigencies of the situation. It is therefore observed that a state of emergency cannot be a permanent feature based by a state. However, it is possible that in actual practice there may be a prolonged state of emergency. The International Covenant on Civil and Political Rights provides under paragraph 1 of Article 4 the following conditions to be fulfilled for taking recourse to derogation. Public emergency should threaten the life of nation. It should be officially proclaimed. It should take measures derogating from their obligations under the present covenant to the extent strictly required by the exigencies of the situation. Such measures should not be inconsistent with its other obligations under international law. There should be no discrimination solely on the grounds of race, color, sex, language, religion, or social origin. Again, the ICCPR under paragraph 3 of Article 4 provides the state availing itself of the right of derogation shall immediately inform the other states through the intermediary of the Secretary General of the United Nations about the provisions from which it has derogated and the reasons by which it was actuated. A further communication should be made through the same intermediary on the day on which it terminates such a derogation. Thus, though the state has freedom to derogate from human rights during the period of emergency, such step taken by it is actually subjected to certain rigorous conditions on the fulfillment of which alone it can legitimately do so. Paragraph 1 of Article 15 of the European Convention on Human Rights provides, in times of war or other public emergency threatening the life of the nation, the state may take measures derogating from the obligations under the convention to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with its other obligations under international law. Again, in paragraph 3 of Article 15 also provides that the state availing itself of the rights of derogation shall keep the Secretary General of the Council of Europe fully informed of the measures which it has taken and the reasons therefor. It should also inform the Secretary General of the Council of Europe when such measures have ceased to operate and the provisions of the Convention are again being fully executed. The African Charter contains no emergency clause and therefore allows no derogation. The American Charter allows derogation in times of war, public danger, or other emergency that threatens the life, that threatens the independence or security of a state part. Now we refer to Siracusa principles and the limitations on derogation. The primary means for interpreting the provisions related to derogation under Article 4 of the ICCPR is the Human Rights Committee, which has the responsibility to monitor and implement the provisions of the ICCPR. However, certain other groups may also assist these bodies in the interpretative role. A group of 31 distinguished experts in international law, convened by the International Commission of Jurists and others, met in Siracusa, Sicily, in April and May 1984 to consider the limitations and derogations provisions of the International Covenant on Civil and Political Rights. The participants had agreed upon the need for a close examination of the conditions and grounds for permissible limitations and derogations enunciated in the Covenant in order to achieve an effective implementation of the rule of law. What is required is a uniform interpretation of limitations on rights of the covenant. Thus, the Siracusa principles may be considered as a non-treaty body making recommendations to state parties as a guideline for the purposes of interpreting Article 4 of the ICCPR. Now, coming to non-derogable human rights. The drafters also added in paragraph 2 of Article 4 of the Covenant on Civil and Political Rights further limitations by providing that certain rights cannot be suspended at all, irrespective of the seriousness of the situation of emergency, designated as non-derogable rights, such as right to life and prohibition against torture, slavery and discrimination, imprisonment for debt, freedom of thought, conscience and religion. The committee also establishes that the rights contained in Article 4, paragraph 2 of the ICCPR are not the sole non-derogable rights, and there may be other rights not expressly mentioned in Article 4.2 that are non-derogable, such as right to fair trial. The Human Rights Committee has also observed that if states parties decide in circumstances of public emergency, as contemplated in by Article 4, to derogate from normal, that is fair trial procedures required under Article 14 of the ICCPR, they ensure that such derogations do not exceed those strictly required by the exigencies of the actual situation and respect the other conditions of fair trial mentioned in Article 14, paragraph 1. There is also a developing consensus that habeas corpus shall be considered as non-derogable. The United Nations Commission on Human Rights has called on all states not to subject this right to derogation. Unlike the American Convention on Human Rights, the Covenant does not provide an extensive list of non-derogable rights. The following steps may be able to better secure core human rights even during emergency, protecting people against the abuse of human rights by the state, but at the same time allowing enough space to the states during emergency to face the exigencies of the pressing circumstances. First, emphasizing the binding nature of all the rights insulated by Article 4, paragraph 2 on the parties to the covenant. Second, expressing heightened concern for the principle of non-discrimination. Third, recognizing the special nature of the rights which have become jus cogens by adopting the principle that even states which are not parties to any of the human rights treaties are bound to respect the inviolability of those four rights. Fourth, emphasizing the desperate need for states parties to conform to the obligations. Fifth, delineating irreducible minimum guarantees of due process and humane treatment for detainees and others subject to emergency measures. Rule of law is another important aspect which should not be allowed to be gravely endangered owing to concentration of power in the executive during the time of emergency. It has been observed there is a correlating relation between widespread abuse of fundamental rights and the powerlessness of the national judiciary. The 1961 Lagos Conference on the Rule of Law recommended that in every case of emergency powers, an aggrieved person of the violation of human rights should have access to the courts for determination of the legality of the exercise of the power. Thus, Article 2, paragraph 3 of the Covenant provides a firm basis for this principle by granting the right to an effective remedy before a competent domestic tribunal. Derogation under Article 4 of the Covenant should conform to the principles of non-discrimination, good faith, continuation of the rule of law, preservation of other international obligations, and minimum guarantees of due process. Margin of appreciation is the other area to which we will enter into. The concept of margin of appreciation refers to the space for action that Strasbourg organs are willing to grant national authorities in fulfilling their obligations under the European Convention on Human Rights. The doctrine of margin of appreciation permits a contracting state the power to assess the factual circumstances in applying the provisions envisaged in international human rights instruments on the justification that each state requires a leeway to balance individual rights and national interests. The position that the margin of appreciation establishes is comparable to that of the concept of judicial discretion, where a judge is subject to certain constraints stipulated in legislation precedent or custom may resolve a dispute within the range of the discretion so as to reach a solution. The discretion becomes indispensable to fill the gap between the law and the changing realities in which it has to be applied. Hence, the doctrine facilitates in addressing questions that may arise in a particular situation where the strict application of law could not have provided an appropriate solution. It is possible to deduce certain principles on the basis of which European Court has been determining the validity of the restriction on the rights imposed by the state under the doctrine of margin of appreciation. One of the first principles that may be taken into consideration is the principle of effective protection. It is therefore possible to hold that the intendment of the European Court of Human Rights is that, in deference to national sovereignty, the provisions of the Convention are required to be given restrictive interpretation as decided in Lawless versus Ireland, or Ireland versus United Kingdom, or Bunningham and McBride versus the United Kingdom, or even Handyside versus the United Kingdom. The principle of subsidiarity is the second principle where the relationship between European regional human rights law and domestic law has been amplified by the court, according to which European human rights law would not reject domestic law altogether, as decided in Astin and others versus the United Kingdom, decided in 2012. Third is the principle that the rights mentioned in the Convention should have to be regarded as conditional and may be interfered with particular circumstances in consonance with the Convention and the case law as decided in Malone versus the United Kingdom and also Sunday Times versus the United Kingdom. Fourth is the doctrine of proportionality. The doctrine of proportionality is the determination into the reasonableness of the restriction, since the principal task of the court is to make sure that the rights laid down in the Convention are not interfered with unnecessarily. The principle of proportionality urges that there should be a reasonable relationship between a particular objective to be realized and the means used to achieve the objective, as it was decided in James and others versus the United Kingdom. The fifth principle applied by the court, the European Consensus Standard, which is a generic label to explain the court's inquiry into the existence or non-existence of a common ground, mostly in the law and practice of the member states, justifiable on the ground that the existence of similar patterns of practice or regulation across different member states will legitimize a wider margin of appreciation for the states that stays within the framework and delegitimize attempts to part ways with them, as it was decided in Rasmussen versus Denmark in the year 1984. However, the margin of appreciation goes hand in hand with the European supervision. The rationale behind the European review resides in the court's fundamental role as an arbiter between the states and their citizens. This implies the need for the court to establish a fair balance between two diverging interests. That is, the interest of the states in maintaining a wider power of discretion and the applicant's interest in benefiting from a higher level of protection. Now I come to the conclusive part of my discussion. The global concern over the observance of human rights and the demand for the high priority to deliver justice for violations of human rights, both within domestic as well as in international tribunals, may be regarded as an amazing development in the history of international human rights law. Amazing because a century ago, no one could have conceived the rapid development of the history of human rights. With the rapid development of the communication that has brought about, the fluidity over the transactions across the international borders, the individuals in one state would be immensely influenced by the occurrence of the events in the life of another in a different state. This was the turning point to raise the conscience of the peoples in different parts of the world to be concerned and sensitized by the incidents of encroachment over the personal property in other parts of the world. The object of the human rights is to confer preparedness to demand as well as to enjoy minimally good life with optimal quality, free from interference with their permissible behavior, ensuring equal justice before law and providing opportunity to realize basic needs.